Both these RPFCs are filed against the judgment and order dated 9/7/14 in Criminal Miscellaneous number 230 of 13 on the file of Principal Judge Family Court at Gadag, partly allowing the petition filed by the wife under Section 125 of the Code of Criminal Procedure. RPFC number 100113 of 2014 is filed by the husband against the said order of guaranteeing maintenance of 4,000 per month, whereas RPFC number 1000015 of 2015 is filed by the wife for enhancement of maintenance. The parties are referred to as they are referred to in RPFC number 1000015 of 2015 filed by the wife for the sake of convenience. The brief facts of the case are: the case of the petitioner bar wife before the family court is that she is the legally wedded wife of the respondent, and their marriage was solemnized about 40 years back as per the Hindu customs and rituals prevailed in their community at the time of marriage. The parents of the petitioner bar wife have given 10,000 towards Varopachara, and they have also given watch and clothes to the respondent husband. The petitioner has led a happy marital life with the husband, and out of their wedlock a daughter was born by name Basawa, and thereafter respondent husband started harassing the petitioner, stating that she has given a birth to a daughter and not to a son, and he used to abuse her and she used to bear inhumanity. In spite of the same, respondent has contracted second marriage with an intention that the petitioner will never give birth to a male child, and hence thrown her out of the house. He has not made any arrangements for her maintenance and her daughter till today. She also concluded that she is staying in her elder brother's house, and respondent has not made any arrangements for maintenance, and she has been maintaining her daughter at the mercy of her brother. In spite of several requests made by the petitioner to help the marriage of her daughter, respondent has not helped to perform the marriage of his daughter. Therefore, the petitioner alone celebrate the marriage of her daughter with the assistance of her elder brother. It is also contended that the petitioner is now aged and he is not in a position to do any work. Her elder brother is aged and he is not in a position to support her. The respondent has got the obligation to maintain the petitioner as he is the illegal wedded wife. In spite of the advice of the elder and well wishers, in March 2013, respondent stoutly refused, and he has not given any respect to the elders, and he has abused them in filthy language and refused to maintain the petitioner. It is also the case of the petitioner that she requires at least 8,000 per month for her maintenance. Respondent is having 11 acres of fertile land and is getting income of more than 5 lakh per annum. In addition, he is running a dairy and also owning a tractor and earning more than 2 lakh per annum from milk vending. Hence, respondent is having a capacity to pay the maintenance. Therefore, she filed the petition for maintenance before the family court. After receipt of the notice from the family court, the husband filed a statement of objections denying the very relationship between himself and petitioner. It is the case of the respondent husband that the allegation made in the petition are all false and far from true. He has specially contended that the petitioner is not at all the legally wedded wife. He has not married the petitioner about 40 years back, as stated by her. Therefore, question of receiving any Varopachara watch and clothes does not arise. He has also denied the birth of the daughter of name Basava and his specific case in that he has married one Gangava and he has got two children. Records revealed that the petitioner is the wife of one Basappa Nukapur and not his wife. The petitioner has created a story colluding with the ill wishers of the family and succeeds in creating voters list and other documents recently by showing the name of the respondents. When the petitioner is not at all the wife of a respondent, there is a no obligations or duty to provide maintenance to her. Therefore, he prays for dismissal of the petition. Upon considering the pleadings, the family court framed the following points for consideration: whether the petitioner proves that she is illegal wedded wife of the respondent and their marriage was solemnized about 40 years back as per the customs prevailed in their community; whether the petitioner proves that she has led marital life with the respondent for more than 8 years and she gave birth to a daughter, namely Basava; whether the petitioner proves that the respondent has taken a second wife by name Gangava and thrown out his petitioner and her daughter about 30 years back and he has completely neglected and deserted the petitioner and her daughter; whether the respondent proves that the petitioner is no way related to him and the petitioner is not his wife and he is having a wife by name Gangava and he has got three children and leading his matrimonial life with Gangava; whether the petitioner is entitled for a monthly maintenance of 8,000 and litigation expenses of 5,000 from the respondent. What is the order? In order to establish her claim, petitioner wife examined as PW1 and two more witnesses as PW2 and 3 and got marked documents exhibits P1 to 8. On the other hand, in spite of the grant of sufficient opportunities, respondent husband did not adduce any oral or documentary evidence. Though he has appeared before the court, he has not cross-examined PW1 to 3. After considering the entire material on record, the family court by the impugned order dated 9/7/14 allowed the petition in part granting maintenance of 4,000 per month to the wife from the date of filing of the petition. Against the said order, these revision petitions are filed by the petitioner wife for enhancement and respondent husband for setting aside the order of grant of maintenance as stated above. He heard the learned counsel for the parties to the lies Shri H.N. Gulareddy, learned counsel for the husband who is the petitioner in RPFC number 113 of 14 has contended that the impugned order passed by the family court granting 4,000 is illegal and contrary to the law when the marriage itself is in despite question of granting maintenance to the wife does not arise. He has also contended that respondent is married to one Gangava and got three children. Respondent never married Dyamova as his wife. Therefore, question of granting maintenance does not arise. Therefore, he has sought for setting aside the order of the family court. Sri Chandrasekhara P. Patil, learned counsel for the wife, who is the petitioner in RPFC 1015 of 14, sought to justify the impugned order passed by the family court and prayed for enhancement of maintenance amount. I have given my thoughtful consideration to the contention urged, and perused the entire material on record, including the original records from the family court.